Well, if it's the case that these are the more degraded prints, then therefore that means must be Patsy because dad's fingerprints on gun.
I didn't say must be
Describe
Patsy.
how this actually links in to Robinson being a.
Well, she said likely Patsy, or it's evidence of Patsy. So she'll say stuff and walk it back. She does this often.
Patsy.
Okay.
Yeah. What is the causal nexus? What is the connection there? Because there is no connection. I
just described that for you, so I can explain it to you, but I can't understand it for you, so I'm going to move on from that. But to just go back to your point.
So she's running. There is no connection. She did not actually say any connection there. It's crazy.
Yeah, again, this is non sequitur. So she really needs to come with something stronger on this first point here.
Does she get away with stuff because she is pretty? Oh, I think because she talks fast and confidently. I think you can get away with a lot when you speak in that way.
Point about this is not evidence. You can't make that claim because the entire basis for why you think that there's evidence for Tyler Robinson being the person that took the shot is based off of a hearing under Utah 1102 rules, meaning that they are doing the exact same.
Now, wait a minute. This is now shifting over to the Utah rules, and this is not addressing the non sequitur challenge. So this seems to be a deflection at this point.
Thing that I am doing. This is the state. You said you're here to represent the state. Well, did you watch the preliminary hearing?
I didn't say I was here to represent the state.
The state's position you think is strong and convincing.
What I'm here to do is represent my own.
No, that was again, Andrew did not say that he's there to represent the state. So even if his position is the same, he didn't claim that he is representing the state.
You said in your opening statement,
based on
he's just saying that he agrees with the state.
The evidence presented so far by the state.
The state has presented evidence under Utah's 1102 rule.
But this doesn't demonstrate any Patsy.
No, that's very important because that rule is hearsay. So you can't say at the same time, Candace, you're not allowed to.
So this is why we're listening to Alex's here, because hearsay becomes a key point here, and hearsay and circumstantial evidence can be admitted.
Hearsay is permissible. Let me tell you, there are like 30-something exceptions to the hearsay rule. Like, let's just go into, I'll bet you Utah's rule of evidence is pretty similar to the federal rules of evidence. Let me show you guys. Okay, so here in the 800s, you have the rules against hearsay, right? So 801 defines what hearsay is, right? So it's a statement. It's a statement that the declarant does not make while testifying. So it's an out-of-court statement that the party offers an evidence to prove the truth of the matter asserted, right? Within that statement. So this is the definition of it. Now, if you keep going through the rules, 802 says basically you can't have hearsay. And then 803 is exceptions to the rule against hearsay, okay? 1, 2, 3, 4, A, 4B, 5, ABC, 6, ABCDE, 7, ABC, 8, A1, A2, A3, 8B. These are all exceptions to the hearsay rule. I think there's 23 here. 24 is like a catch-all transferred to rule 807. Okay, so in rule 803, you have 23 exceptions to the hearsay rule. There's a joke in litigation that says if you can't get hearsay in, you must not be a very good lawyer. Like, we joke about that. There are a billion exceptions to the hearsay rule. Yeah, so the statement is supported by a sufficient guarantee of trustworthiness. So this is just a catch-all, leaving some discretion to the judge to permit hearsay to come in sometimes, right? So
he's saying that from a legal perspective, the Utah rules are probably the same as the federal.
Oh, there are plenty of exceptions to the hearsay rule. There's a ton of them. They are all over the place. So the fact that something is hearsay does not automatically mean that it's not admissible evidence, right? So there's, again...
By the way, this is Tim Gordon's point as to why the text messages that suggest Middle Eastern potential involvement could still be admitted as evidence, right? That was a point that Tim was making, that, well, if Tucker, Megyn Kelly, Candace, and Harrison Smith have evidence of Charlie and people in Charlie's circles saying that there's a motive via Middle Eastern people, that could still potentially be evidence.
Like close to 30 exceptions, if I remember correctly, to the rule against hearsay in evidence. Hearsay can be admissible evidence if you find a way to fit into one of those exceptions.
And what that means under the Utah rule, which I'm sure you know, because I'm sure you watched the preliminary hearing and yourself understand what that means, is that the entire hearing was hearsay. It means none of that information that was presented is going to be allowed. The majority of it, the overwhelming majority of it, is not going to be allowed at a trial. They're allowed to present when it's just appropriate.
She doesn't know that.
That's I don't think that's true. And that's both. Now, remember, Tim Gordon is much more on the conspiracy side of this and would immediately correct her and say, no, hearsay and circumstantial can be admitted. That's not true.
She doesn't know that. right? So some of it is permissible hearsay. Some of it can be permissible. Like, these are all decisions that are going to be made later by the judge.
Probative
I
hearing.
don't think all the evidence that was put in was hearsay.
Okay, you didn't watch this case.
But not only that,
No, this is a huge point.
I
This
want
is-
to.
this is-
But even if it is, it doesn't matter. That's like this whole line of argument by Candace doesn't matter. Because hearsay can be admitted in if you can get it to fit into one of the exceptions. And this is something they're going to decide later. Basically, prior to a trial, you have a time period for what are called motions in limine. This is like when you're going to exclude evidence, or like you could even argue to try to get evidence in. And a lot of this will just be sorted out at trial itself, where they'll present something, the other side will object and say, Your Honor, that's hearsay. And then, you know, the person presenting, the lawyer presenting the evidence will say, Your Honor, this falls under the exception under 803B or 803C or something.
There you go. See, that's a key point that she seems to not be aware of.
3D. Right. So they'll duke that out in court, and they can actually preserve those issues to be revisited on appeal. You can appeal merely on an evidentiary issue if they think they got the hearsay wrong. So Candace acting like all of it's hearsay, it's not going to be admissible at trial. None of this is correct. She is guessing on all of this. She doesn't know.
Crazy
We
that you
can call
don't know
for a
this.
fact check if
Yes,
all the
well, we
evidence
need more
was
than a
put
fact
in.
check. This was every single
The
day.
truth of the matter
Utah
is actually
Rule
saying they want to
1102.
go there. So they said there's a medical examiner's explanation of the shooting that's in the back. Rob, if you want to pull it up, and then Candace, if anybody from your team wants to pull something up.
How is she winning? She's not winning. She hasn't presented any evidence. All she did was prove Andrew right on the evidence of the gaps.
Yeah, again, I've so far my assessment, my scoring from the philosophy vantage point, I've got 1 point Candace, 2 points Andrew so far.
She doesn't understand the hearsay rule, and she's pretending that she does. That's the worst part. So
Now, I mean, we might have to give Andrew a point for this too, because if she's hinging a huge amount of argumentation that because it's quote hearsay will be thrown out, that seems to be a pretty significant mistake.
because this is on Candace Owens' channel, I'm just gonna give this a quick.
Up, no problem as well, but they're requesting that if you guys got it, pull it up so we can show it. And in the interim, is that it?
Yeah. So I'll read this.
Just what-
Yeah, hearsay is an out of court statement offered for the truth of the matter asserted. And there's like a billion exceptions to that. Like we joke about this in litigator circles. So like, you couldn't get that hearsay in? Like, what's wrong with you? Everybody should be able to get hearsay in. There's a billion exceptions to the hearsay rule.
What are we looking at, just so we know?
Yeah, so this says the bullet, or at least part of it, sequentially perforated the interior left of Mr. Kirk's neck, strap muscles of the left side of the neck. This is a summary, by the way. Left common cartoid on the left internal external jugular veins. The bullet also obliterated the left side C27 vertebrae, transacted the cervical spinal cord. Medical examiner observed a significant portion of Kirk's cervical spinal cord was traumatically absent. Mr. Kirk suffered from other severe injuries, including bilateral, apical, and posterior intercostal hemorrhages, pulmonary, apical hemorrhages, multiple disruptions to the thyroid, et cetera, et cetera. So the summary of the examination said he was shot.
Okay.
That was what they were pulling that up
Okay,
for.
and I'm not disputing that he could have been hit with a projectile. We're not disputing that, so I don't know why this was brought up as a fact check. Could you bring up 1102 Utah Rule? Because this is an unbelievable point that you're making by saying that I am not allowed to infer off of evidence.
You can infer. I'm trying to follow the inference.
But your entire reason, like you asserted that you believe there's overwhelming evidence on the basis of what we saw in the
Correct.
preliminary hearing. The entire preliminary hearing was hearsay.
Yeah, I'm fine with your inferences.
But no, you just literally said I couldn't do that. Yes, I can.
No, I didn't. I'm just saying from your inference, how do we get to Patsy?
No, it's fine. I'm trying to pull up the YouTube.
Yeah, no, this was true. Like Andrew didn't say you can't make an inference. He said, how do we get from your inference to Patsy? And so Andrew is outlining what I said, which is non sequitur.
Rules of evidence in a criminal procedure, and it's not pulling up because everybody's searching it. It's like crashing out right now.
This is how you got to Shooter. Tyler Robinson did it.
No,
the same
no,
way
no,
that
I
you
didn't
got to
get to
Tyler
just Shooter
Robinson.
from that.
Yes, you did. You again, this is something.
No, this was Andrew did not quote get to Shooter from the fact that there was just one line of argumentation. So that's not true.
Important. So we should pull up a fact check about what the 1102 Utah, under their constitution, for the sake of a preliminary hearing, they do not have to have hard evidence. They don't have to put people on the
I
trial.
agree, they
Swear
don't
them
have
in.
to.
But no, that's why the entire hearing was basically hearsay. Officer Bagley
But
was
not
saying
all of it, like I said.
Yeah, but if she's wrong about this and hearsay being admitted, which Alex is pretty clearly pointing out is false, this is a huge mistake right here. So I'm going to go ahead and give 3 points for Andrew so far.
Overwhelming
And
majority.
again, no
I mean,
disputes.
outside of the one
Well,
that you don't want to
that's
get.
not
Please
what's
don't
in
cut me off.
dispute, though.
Outside of no,
It doesn't matter. It's the thing. Like this does not matter.
that is what's in dispute. It means that your entire brand of saying you don't have evidence falls apart when the entire preliminary hearing is based off of hearsay. In fact, Lance's
Hearsay can be admissible. I can't believe that she's talking about this. This is crazy.
This is a huge mistake right here.
testimony before they had about an hour debate. Actually, maybe it was more than an hour debate before he sat, and they said this is not going to be allowed. You wouldn't even be allowed to do this. We'd be able to cross-examine him. The questions that they're asking Lance are all leading. And what did he say? Well, I'm the magistrate.
No, again, I think I've been fair because I admitted again, and I agree with Tim Gordon, the claim that there's no evidence of Israeli involvement I think is a little too strong, because Candace did point out, although she should have shown it, this was a huge blunder for her. If you're going to say that my Israeli claim is based on Tucker's text, my text, Megyn Kelly text, and whoever else, Harrison Smith, then she should have shown that. But I gave her 1 point for that because I don't think there's no evidence.
Utah Constitution, 1102. It is my job to allow all of this so we can see if the state has enough here that we can then move to a trial, which will then, they would not allow this stuff. They would say we get to cross-examine Lance. Lance
But
just
you're
can't
arguing
willy-nilly
things I'm not
say,
disputing.
but the entire substance of your argument is that people can't infer off of evidence.
No,
That's what you're saying
it's
to me. When
No, that's not at all. That's a total mischaracterization. That's a straw man. So Candace did a straw man to say that you cannot infer off of evidence. Andrew did not say that. Andrew said, I don't buy your inference to Patsy from that.
Oh, he's saying that what she is presenting does not necessarily lead to the conclusion that Tyler Robinson is a patsy.
Correct.
Just because you have different fingerprints on the gun, that does not lead to the conclusion that Tyler Robinson is a patsy. So Candace here is obfuscating. She doesn't even, I don't know if she understands even what the point that issue is or what the point that Andrew is making is. She might actually be dumb, guys. Like,
yeah, I don't think she understands that Andrew is making that he's saying it's a non sequitur. I don't know that because I think she thinks that her line of reasoning just kind of is an argument, and it's not necessarily. That's why we're getting to this point that it's not just whether you have the right theory, it's whether you have the right line of argumentation to get to that. Do you have solid grounds to believe that? This is what we said at the beginning, right? Plato's episteme versus doxa. Doxa, opinion, episteme, knowledge.
this is pretty bad for her. She's pretending to know the rules of evidence when she doesn't. You need to go to school. You need to go to law school, take evidence 101. And even that's usually not enough. You probably need some time actually practicing in litigation to really get a good grasp of the rules of evidence. She does not know the rules of evidence. Not even close.
You say, Candace,
Here,
you
I'll
can't
give you
talk
the
about the great
argument
inference, which is a
now.
fact,
Yeah, I'm
and
not
then
saying
infer
that.
off of that
Didn't say that.
Tyler could have been a patsy.
You're just
I am telling
literally
you,
making stuff up. So
I'm
here's
not
what the
making stuff
position
up.
is.
I'm
I'm
not
asking
making
this.
stuff up. I'm saying, and I'm saying you, let's pull that up. Let's pull that up. I'm doing exactly what the state did. I'm looking at a piece of evidence. and I'm saying,
So Alex has it on fast, and I have Alex on fast. So let me slow it back down here because it goes back and forth.
Show me how you get there.
Can you
from the
describe to
inference.
the audience what
Yes.
Rule 11
So this, just so everybody who's watching this at home understands what I'm saying, even if he doesn't. What Andrew is arguing is that I don't have the right to extrapolate from
Never
a
made that
fact
argument.
like
Just making-
No, again, she doesn't get it. She doesn't understand that it's a invalid leap because she even earlier admitted that it's a possibility. Well, if it's a possibility, then other things are a possibility too. So how do we know that your possibility amongst the array of possibilities is the one that we're supposed to choose? That's the question that's being asked. Not, can you make an inference? So she's deflecting.
it up.
Yeah.
Just purely making it up. I'm asking based on
Andrew,
based on
can I
your
show my evidence? You just showed yours. Reliable hearsay.
You'll get a chance.
Reliable hearsay in criminal preliminary examinations. The entire preliminary hearing that you just saw was on the basis of reliable hearsay. And what that
So reliable hearsay is admissible at criminal preliminary examination.
So look, she doesn't even realize that the very Utah State Court line right there says reliable hearsay is admissible. This was a huge mistake right here.
For purpose of criminal preliminary examinations only, reliable hearsay includes hearsay evidence admissible at trial. It's literally the first thing.
So now I want the people in the audience who are de facto just out of hand, no matter what, supporting Candace. Can you be honest and admit that is factually false right there? And Alex has it pulled up that Utah State Court 1102, the very thing that Candace appealed to, says that, I'll read it. Hearsay evidence admissible at trial under the Utah rules of evidence. Hearsay evidence admissible at trial under Rule 804 of evidence, regardless of the availability of the declarant at the preliminary examination. So that's the very opposite of what she thinks is this knockdown initial early point.
B1. Hearsay that's admissible at trial. Hearsay evidence admissible at trial under Rule 804, regardless of the availability of the declarant. So they're saying that there's a bit wider discretion at a criminal preliminary hearing. You don't have to produce the declarant, but at trial, you will have to produce the declarant. So this is still going to be scrutinized at trial. Evidence establishing the foundation for the authenticity of any exhibit. So that's fine. These are usually just like signed out of court declarations or affidavits or something. Scientific laboratory forensic reports, medical. Okay. These are all normally admissible anyway. Like police reports and stuff from like the judges that I've dealt with, they have pretty wide latitude because they know that the officers, they will be produced in court and they have the opportunity to cross-examine them. So this is not out of the ordinary. Candace is not like getting on something. She's not found something crazy here. These are normal rules of evidence that permit only reliable evidence, even when it's hearsay. So she doesn't understand the hearsay rule. She doesn't know anything about the rules of evidence in court. This is insane.
That means essentially is the people who are making the statements can just say, Patrick told me that.
And I hope you guys in the audience see, this is why I was making the jokes about her not understanding language, pronunciation, and reading comprehension. People were saying, who cares? What does this even matter? Here you see why. Because she is not reading this actual document and comprehending what it actually says.
He did this on Monday. Patrick's not here. And that is, they can allow that into the hearing. That's just because it's just meant to be probative. And so it's the state saying, here's what we have inferred.
No, that's not true. There's, okay, literally evidence 101 is that all evidence that's presented in court, there's a balance between it being probative and prejudicial, right? So there's evidence that it could be very probative, but it could unfairly prejudice the person. This is why you need a judge there, because they make these decisions on whether the probative value of evidence, which is like what it shows you, whether the probative value outweighs the prejudicial effect on the person in question, whether it's a witness or whether it's a defendant in that case, or a plaintiff even in a civil lawsuit. So yeah, she does not understand evidence at all.
So you are allowed to take a piece of evidence and then you are allowed to infer off of that evidence. Okay. Case in point, that's
yes, you are allowed to make inferences. Andrew.
Yeah. Again, she is refuting a straw man. Andrew did not argue that you cannot make inferences. He said your inference is a leap. And now she's deflecting. Either she doesn't understand or she's deflecting to get around that objection.
Demonstration of, to give you, that's a demonstration of what I just did. I said the prints were the most degraded off of Tyler Robinson. And from that, what I am inferring is that it's plausible that Tyler Robinson was set up.
That doesn't, that's the point in contention.
That's not a point in contention. That's
the point in contention.
So that is the point of contention, because you need to demonstrate why we ought to accept that inference from multiple prints. And she's just saying, well, then that means he's a patsy. And then she walked it back and said, well, he could be. Well, this is different. So you've moved the goalpost and you have set up a straw man.
It's not a point in contention. If you're saying it's a
it
point,
is the point in contention.
It's not the point in contention. I'm telling you that is what the entire hearing allowed for. So the evidence that he is describing,
we're asking you
that he is using to argue his case, is all based on inference, not fact.
Great.
Inference, not fact. So what they are inferring.
Again, she's confusing that. She just thinks that you can just do like it's like a free reign. Like, well, you can just do inference. We all do that. No. That doesn't mean that yours are good. That's why we're getting into doxa versus episteme, right? It's your opinion that it makes him a patsy, but you need to demonstrate why we ought to conclude that from that.
Off of the facts.
That's not.
Now, see, you notice right there, we're beginning to see a pattern of what she just thinks are just the facts, and she thinks the facts tell her story. So I'm beginning to, and I don't know, but I'm beginning to detect a kind of Protestant idea of the way that brute facts just work. And this is what we see with most evidentialists, most Roman Catholics, most of the evangelical evidentialist crowd, and even the Muslims. They think that they're just brute facts, and they don't understand that, well, you have an interpretive framework by which you read those facts that makes you read it towards your assumptions. And what we're doing in philosophy is questioning how you got to that endpoint. Maybe you're correct. And in fact, you could be correct with bad reasoning, you see. That's why epistemology matters. Because like Plato said, you could have a correct opinion, but that's not knowledge. That's not episteme. Because you didn't have good reasons for that opinion.